Jordan's last party. On August 2nd, 2014, 20-year-old Jeffrey Rushing attended an after-party with many of his friends, including a beautiful young lady named Jordan Nedeau. That was Jordan's last party. She ended up dead in the early morning hours in a vehicle that became submerged in a river off Tower Road in Tallahassee. Seasoned criminal defense attorney Tim Jansen, with Judge Terry Lewis presiding.
As the pavement is going to end, and it does, that does not alarm him in any way to stop, brake, where am I, turn around, nothing. He keeps going. 25 miles or 30 miles per hour, he estimates. Down a dirt road, unfamiliar, sees a dead end sign or doesn't see it, ignores it, or fails to observe it. That's an indicator of impairment. And then just drives right in the river. Those are indicators of impairment, and that's evidence of the reckless behavior that is required for the vehicular homicide count 2. So you've got everything that he consumed: beer, Xanax, liquor, cocaine, marijuana, no seat belts, no headlights, not familiar with the area, ignoring the signs, not stopping. So clearly he should not have been driving that night. So then the question becomes, was he driving? What's the evidence that he was driving? Is it a mystery that you guys need to solve? Whether he's driving or really it was Jordan that was driving? Well, what evidence do you have? It was his car, number one. Number two, Ryan Degg saw him driving, and he lives, 1 mile, less than a mile from where the crash occurred? That's where he got dropped off. And when he got dropped off, the defendant was driving. There was no conversation about his driving being terrible on the way to Ryan's. There was no conversation about switching drivers. There is no reason to think that they switched drivers. Number 4, he told Deputy Davidson that he was driving. He hadn't forgotten who was driving due to blackout. He remembered, and he told the deputy he was driving. He wasn't being interrogated. He wasn't under arrest. He was there of his own volition, accompanied by his mother, who apparently did not have reason to believe that he was suffering from a head injury or a blackout or was medically unfit to go up there and give statements to law enforcement. And he said he was driving that car and wrote it in a written statement. He also told Detective Revel that he was the driver. In both interviews that you have with Detective Revel, he talks about being the driver, doesn't just say, I'm the driver. He gives specifics. I remember turning onto Old Bainbridge. She was telling me where to go. I remember Tower Road. I remember when it turned into dirt, and then, by God, that river just jumped right out in front of me. He says, I've never been down that road before. She done gave me directions, but she didn't say nothing about a lake coming up or slow down or nothing. So he was relying on his passenger to guide the vehicle or to give him instructions on how to drive this vehicle. Well, she was high and drunk. She told me to go right and go left, and then that's the end. I'm hitting the water. She was directing me where to go. I think I went right there, took a right out of Golden Park. I'm sure I was going probably about 25, I would say 30 maybe. Because this morning, more than anything, that dead end sign, I damn sure messed up. I remember turning onto Old Bainbridge.
They call hospitals. They try to find out where the car is 2 times. They go down to the landing. First time he says, not sure this is it. Doesn't have the recall the first time. They don't see the car in the river. They go back. And apparently then they make some more phone calls, and then they decide, or he decides, to contact his mom and then they go to the police station on the phone. Mom didn't get a lawyer, didn't say, hey, what you did is so, we better get a lawyer, don't make a statement. No. Mother, father, grandfather, go to the police station. They go to the duty station, put a missing persons out, put a missing vehicle out. And while they're there, they meet Miss Davis. Relatively young, relatively inexperienced patrol officer, friendly enough, but says he wasn't making sense, he was a bit confused. Of course, she's not going to recognize if he suffered a blackout. She had never encountered this guy. She didn't even know what happened the night before. She's looking for a call. But she's not going to spend resources if they can't get more information. So he gives a written statement, and it's curious, the written statement, inside the statement itself, again, it gives. He can't recall. He writes in the statement, I don't remember. Oh, I'm sorry. I have very little recollection in his written statement. And this is at 9:30, 10:30. I have very little recollection. But yet the state wants you to believe, oh, you should believe everything he says, even though he says he doesn't have recollection. Or whatever he says that benefits him, disregard. Anything that possibly hurts him, you can believe that. And that we don't need to investigate. It doesn't work that way. We don't convict people going to the police station and say. People say all kinds of things when they go in there, but it's not true. People believe the mind is a wonderful thing, and sometimes it can be an awful thing. People believe and feel they see things or have done things they really haven't done. So that's why we rely on evidence, investigation, law enforcement that's trained, traffic homicide people that are supposed to be specifically trained to investigate, document, bring in evidence.
That you could come up with all these wild, possibilities we've been talking about. Counsel said something really interesting in opening statement, which I wrote down. I don't remember if y'all remember, but he said the mystery bit, and then he said the driver of the vehicle is the one that's responsible. And he went on to say, there's not going to be any evidence that my client was the driver. But I do agree with him that the driver of that vehicle is the one that's responsible. But aren't we saying something else now in closing argument? Didn't we just hear that lots of other people and other targets are responsible? Ignore those statements. Don't ignore the other evidence in the case. Look at all of it and render a verdict that speaks the truth. There is no mystery here, folks. Took a long time to get there, but it's not a mystery. There is only one verdict that speaks the truth in this case. There is only one verdict that will do justice for this beautiful young lady, and that is a verdict of guilty as charged. Please find him guilty. Thank you.
And thank you. All right, record reflect all the jurors are back and the defendant is present. And I believe, Mr. Novinario, you are the foreperson. I think I remember seeing your name on questions. I understand the jury has reached a verdict.
Yeah.
Is it a unanimous verdict?
Yes.
All right, if you'll hand the form then to the bailiff. And I'll ask clerk if you'll publish the verdict.
In the case of the state of Florida versus Jeffrey Rushing, the jury finds him guilty of manslaughter by driving under the influence. Count 2, vehicular homicide, guilty. Count 3, leaving the scene of a crash, guilty.
Thank you. Either counsel wish to have the jury polled as to the verdict?
Yes, Your Honor.
Okay. The clerk's going to call you either by name or number, and if this is your verdict, please say yes, and if it's not your verdict, say no.
David Nelson, you're number 1.
Yes.
Number 2, Carrie Anderson.
Yes.
4, Deborah Brown.
Yes.
Yolanda Gerhardt. Gerardo.
Yes.
And Livorno.
Novinario.
Thank you. Number 6, sorry.
Did you call Mr. Hurlin?
Oh, did I miss
He was the alternate that got put
I
in.
missed him, didn't I?
Yes.
Thank you.
All right. Folks, and Mr. Jansen, I generally give you the open and closing part on
Yes, sure.
on the sentence. So I'm happy to hear from you. Oh, but let me tell you, I did see a motion for downward departure, and I've read numerous letters that were given to me this morning.
Yes, Your Honor.
Okay.
Judge, we're here for the sentencing, and you were the trial counsel. So factually, you are aware of the facts of the events. You're aware of the evidence that was introduced, and you're aware of some of the evidence that was not introduced. So there's no more appropriate person to handle the sentencing than Your Honor. Your Honor, this is a tragic case on many levels. Mr. Rushing, who has no prior record, who was an academic student, valedictorian of his high school, nice person. He was friends, his good friend. She didn't deserve to lose her life. She was a beautiful young person. Both of them very young. My client is 21 at this point, 21 years of age. The guidelines, Judge, in this case, as you know, the court, and I don't think we have any objection to the guidelines, as guideline range is 145 months, and I believe there's a 4-year minimum mandatory sentence. What we did, Judge, was try to give you a basis to depart down from the minimum mandatory. We believe there are actually two potential basis that the court could find by preponderance of the evidence that would apply for the court to take into account the totality of the circumstances and tailor a sentence that the court feels is just. One under 921.0262I, which the defendant cooperated with the state to resolve the current offense or any other offense, and then J, it's an unsophisticated manner, isolated incident for which he has shown remorse. This was an extremely rare case, Judge. This is a case where our client, even after he suffered this event, after he abused drugs, got in the car, they drove, had the accident, survived the crash, wandered around for a while, then brought it to the attention of his friends, then tried to locate the car and his friend, and then went to the police station on his own. Well, I guess I know there was some facts, some people were telling him he needed to go, but he then went to the police station with his mom and spoke to the duty agent and explained to her what had happened about a crash, about his friend being in the car, about her not being able to get out, and he stayed there. He never asked for a lawyer. He never left. His grandfather was law enforcement. His grandfather was a deputy, retired deputy. He stayed there, gave a written statement. He then stayed there and gave 2 recorded statements. And at all times, he did not reflect or anyway not assume responsibility. He did have a genuine concern about his memory, but he let them know what he drank. He let them know what he took. He let them know he was under the influence of drugs, and he tried to recapitulate what happened to the best of his ability. At that time, the police officers and no law enforcement knew of the car in that lake. They knew she might have had a missing person only because he put the missing person out, and then maybe his family did. But he brought this crime to the police. He admitted he was driving. That's clear from all the interviews, recordings, and his written statement. He admitted that he was impaired, that he had ingested both drugs and alcohol to the excess. He told the police that night. He still to this day, though, cannot tell you how he got out of the vehicle. And what we believe, Judge, based on the facts of the case and the witnesses, and these are much of this evidence I've just described to you, Judge, came from both police and witnesses and friends and my own client's statements and the police interviewing him. he did give this information to the police to allow them to investigate it. And basically what he did during that, on August 2nd, that confession that he basically gave regarding the death of his friend Jordan solved the case. So we believe under I that he would fit that category based from a factual and legal standpoint. He led them to the location. He told them what happened. He told them about his drug use. And I can tell you, Judge, the evidence that was collected later, maybe it should have been collected sooner, but his own statements allowed the jury to find him guilty. Because, as you know, Judge, the toxicology screen showed no alcohol, showed no drugs, no Xanax, and it only showed metabolites for marijuana. And in this case, impairment was an element of the offense or offenses. So we believe that he did do the necessary requirements to satisfy that possible departure. The second departure, Your Honor, we ask for when the offense is committed in an unsophisticated manner, isolated, and he has shown remorse. Now, the remorse is not the remorse. I think you look back at his interview with the police officers, he accepted responsibility, and during the interview he said, I made a mistake, I can't believe what I did, I don't want to make another one. And then he continued to take responsibility. As you know, Judge, remorse by the Supreme Court and case law is determined at sentencing. The court can find that he satisfied that element of remorse at sentencing. Prior to sentencing, this court ordered a pre-sentence report. He was interviewed by himself with the probation officer present. No lawyer was there. No lawyer prepared him or told him what to say. And then you look at the pre-sentence report, he accepted responsibility, and the interview had to be stopped on multiple occasions because he was crying. He was unable to complete the interview. Her recommendation, disposition, she says, he tried to interview him. He was very open, willing to talk. He was extremely remorseful about the events. He became very emotional on several occasions. On 3 different occasions, the interview was stopped to allow because he was crying and he was upset. They were interviewing his father, found out that he had achievements, and then they tried to get him to maybe write it down so he could present it to the court. He then had to again start crying, and was unable to put the words on paper to attach to the pre-sentence report. No one can replace Jordan. No one can change what happened that night. We have 2 families that are grieving. It's a terrible tragedy. By all counts, my client and Jordan were good friends. They enjoyed their company, and it was nothing more than friendship. It was bad decisions to drive the third person home that evening after they had been partying, and it was a terrible accident. The question, Judge, is where do we go from here? We can't bring Jordan back. You could give him a 100-year sentence. That's not going to bring that beautiful young lady back. And the guidelines tell you, Judge, that you should sentence him to 145 months. Guidelines also tell you that if the court finds by a preponderance that there was some mitigation and that there are clarified facts that demonstrate such mitigation, the court on its own can determine whether or not those factors are factually applicable, and whether or not the court finds in the totality of circumstances of this case, in reviewing the whole pre-sentence report, that a sentence below the guidelines is applicable. You have a kid who was a valedictorian of his high school, who was good friends from all accounts, a wonderful student, a wonderful friend. You have letters from people. who came from a good family, has a drug problem, had a drug problem, had an alcohol problem, not so unlike a lot of our young people. Problem is that road and that unforgiving lake and that unforgiving car did not allow her to get out of the vehicle. He has to, for the rest of his life, live with that. His family has to live with that the rest of their lives. We all are members of this court trying to do what's best for our client, and the state will do what's best they believe for justice. Sentencing to 25, 30 years would not serve anyone's purpose. It'd be above the guidelines. It would not adequately reflect his life experiences, his criminal history, his remorsefulness, and more importantly, the facts of what really happened that night. This is not a young man who jumped in a car and hit somebody that was just walking down the road. These people were together. They were doing things together. They both got in the vehicle with another third party trying to drop somebody off. Tragedy happened. He should not have been driving. We don't know really what happened after the crash. Still don't know. We don't know how he got out. What we do know is that when he was open to the sheriff's office that day, telling him what he could recall, he recalled banging on the driver's door window. And we know for a fact when the car came out, that was the only window that was up. And trust me, he, us, everybody in this room wishes this didn't happen. But he has no prior criminal history. He has demonstrated remorse. He will talk to the court. He's already spoken to the arm of the court, which is the probation officer. And he's already spoken to law enforcement, openly, in writing, confessing, giving statements to the effect that what he did, how it transpired. We're asking the court, Your Honor, to tailor a sentence, and we believe that these departures do qualify. And we do believe that we're not asking you to let him set him free. That would be ridiculous. I would not be able to sleep with myself if I asked you to just let him walk out of here. We're not saying he doesn't deserve prison. He does. But we're asking you to tailor a sentence that will give him punishment, reflect the seriousness of the offense, let the community people know this is not correct, give him a lengthy period of probation and put him under the most stringent conditions that he will not be a danger to anybody else in the future. And if he does violate it, you have a ramifications. You can sentence him up to 75 years in prison. On the other hand, considering his life, where he has, what he has, if whatever future he has, felony conviction, he'll live with that the rest of his life. If he serves 4, there's a 4-year minimum mandatory. Judge, we're not asking you to go below the 4-year minimum mandatory. Not at all. In fact, what we're asking you to give him is the 4-year minimum mandatory sentence, followed by 20 years of probation. Possibly, if you want to give him community control with alcohol tests, GPS, and a lengthy period of probation. We know there's restitution. I was handed the funeral bill today. I don't know if there's any other restitution other than that, but we're not going to object to the restitution. Absolutely not. But we're asking you to give him a chance to prove to this community, to his family, to this court, and I guess importantly to himself, that he can be a productive member of our society one day after he satisfies his punishment.
You mentioned the 4-year minimum mandatory, not asking to go below. I don't think I legally can go below that, can I?
I don't think you can either. And I'm not going to, I wouldn't, even if you could, I probably wouldn't even ask for it. We believe under the circumstances, we believe that certainly the bottom. The those are my arguments, Your Honor. At this point, we have a couple witnesses that we can have come forward, if that's right.
Sure.
I have a Bob Wilder who wants to speak.
Good morning or good afternoon, Your Honor. Thank you.
Yes.
My name is Bob Wilder. I was a school teacher for a long time in Gadsden County. I taught both the parents whenever they were in school. I think they were probably just getting into the high school age when I first started working at the school. So I know both of the parents.
You
and
must
I can
have been just out of high school yourself. You
They-
must have been
they-
just out of high school yourself.
No, sir. I was young, but not that young. I was Teddy Bear, what grade were you in?
I think I was in the seventh grade.
Seventh grade. So they were both young. I say Teddy Bear. The parents, the dad was a big teddy bear. That's what we called him. He played football when I coached football back years ago, and great kid, great running back. And we called him a big teddy bear because he was a good sized kid, but he had the heart of a teddy bear. Mom, same thing. She participated in a lot of stuff at the school. They, of course, after graduation, get married and they have a child that, as a child, the school is from elementary all the way through high school. So I started seeing their son attending school, watched him grow up through the elementary grades. And then eventually I've left the school since this time, but he himself was a good kid. I called him Teddy Bear too, because of his heart and the way he behaved with other kids and always cared about the people around him. I too have a son that died in a car accident, and it's hard for me to talk sometimes, but my son died as a result of his fault. He turned left in front of another car and died in the car accident. So every day I wake up and think about my son, and I know the family's going to go through that every day of their life. I had the opportunity to go visit Mr. Rushing in the jail at Leon. And he is as remorseful as you could ask somebody to be about what happened. If he could have changed it, he would change it. And he will have to live with it for the rest of his life. And unfortunately for that other family, they'll have to live with what happened for the rest of their life. He is a good kid. He comes from a good family. And if you could do whatever you could do to be as lenient as possible with him, I'd appreciate it. Thank you, Your Honor.
Yes, sir. Thank you.
Thank you, Your Honor. Jason Thompson, Your Honor.
Mr.
Your
Thompson.
Honor, I'm Jason Thompson from Quincy, Florida, Gadsden County. I am a recovering alcoholic, and I've worked with Hunter for the past year. Met Hunter about a year ago. He gave me a call, and we've been working with one another on his road to recovery. And I've got a few words I'd like to read since I want to sort of hit everything, if you don't mind. I've known his family for most of my life. Bob was my teacher also. We all played football together. His dad was an idol. He's about 10 years older than me. We all thought those guys were, the New York Giants growing up in high school. So they're all hard-working people. Myself, I struggled with alcohol and drug addiction when I was younger and have been sober now for a little over 10 years with the help of God and the 12-step program. But it took consequences. I didn't just decide to change, on a sunny day when everything was great. Hunter came to me for help after the accident. Since then, he has worked a strong program, and that's the truth. We get together and he's open about his struggles. He goes to meetings. We go to meetings. He goes to meetings by himself when I can't give him a ride. He started working the steps. He's been a guest speaker, telling his story to other people. And, he's serious about his road to recovery. I've seen it. I've seen people come and go, with similar circumstances, sometimes less. I've seen them come and go, and the ones that make it, seem similar to how he's behaved over the course of our relationship. He's sincere and honest about his recovery, and he has a powerful message that he can use to motivate others who may be in need. I didn't know Hunter before the accident. All I can say, Your Honor, is he's on the right path. Recovery is not a one-time decision. It's an everyday choice. And I think he has been willing to face his past mistakes every day in order to turn his life around. And so there are many good qualities that Hunter has. I submitted some of those to you in the letter. He's smart, hardworking, just like his parents. He's very honest. Has a job, goes to school, believes in God. I think his boss is here today. I mean, he's a good kid. He's 21 years old. He's affable. I don't think he has a mean bone in his body. And remorse, you want to talk about remorse, just ask him about his dreams, about his nightmares. We become friends in recovery and friends in real life. And, in my recovery, I try to associate with folks who sincerely seek help and who are willing to do the right thing. I try to hang out with people like that. And Hunter exhibits those qualities. And so for all these reasons, I respectfully ask that any leniency that you can show would be just a blessing, sir. And I've prayed for everybody in here. For me, the power of prayer is real in my life. So I pray for you, Your Honor, and all that you do, and for healing for everybody involved in this matter. And that's all I have.
All right, thank you.
Thank you. I think I have his employer, Zach Helms, Your Honor.
Good afternoon, Your Honor.
Yes, sir.
My name is Zach Helms. I'm the co-owner of Helms & Carter Lawn Care. I was Teddy's employer for, I guess, about 6 months. He came to me, I say about a year ago, maybe shorter than that. And he asked me for a job. He said he was in some trouble. I'd heard about his situation. We weren't close in school. He's actually a year older than me. We were friends, but we weren't exactly the closest friends in school. I knew him, but I didn't know him as a friend. I didn't come to him as a friend and hire him as a friend. He came to me. He took the initiative, came to me and said, I need a job. I need to get to work. I need something to do. At that time, I didn't have any work for him. I guess it was 4 to 6 months after that, we got to where we needed the work, and I called him. And I said, Teddy, if you're still looking for that job, we're ready for you. And he said, I can start tomorrow. So I said, all right. And we hired him on. Now, I'm sure you understand the situation that he had to deal with prior to the trial. I think he was having drug tests once a week. He had his alcohol monitor that he had to get cleared once a week, something like that. He still worked upwards of 40 hours a week for us. He had no complaints about what he had to do. It was just matter of fact type deal. He'd call in the morning, called the automated message to see if he had to go and do his drug test that day. And if he did, he let me know, and he went and did it. And, there's no belly aching about it. He never made excuses for anything. He couldn't drive. My business partner, Matt Carter, he's sitting over there. They live close to each other. And Matt would pick him up every morning. Now, Matt's an early bird. He wants to be at work at 6 o'clock in the morning. So that means Teddy had to be up at 5:30. I don't get up at 5:30, Your Honor. That's intense stuff, and, he was always awake. He was always ready to go, and he was always at work. He was always attentive. He listened, and he did what he needed to do when we needed him to do it. I heard a lot from people in the community. Oh, this is really a great thing you're doing, helping Teddy out. And I believe that hurt me more than anything, because I wasn't helping Teddy out. I needed a job done, and Teddy could do it. And so I hired him. It wasn't out of pity. It was just what I thought was the thing to do. And so that's what I did. And, I was told, oh, you're really helping him, and maybe you can teach him some things and guide him along. That's totally opposite, I think, of what happened. We never really talked much for a while. I guess for the first month or so, didn't consider it to be any of my business what he did. He was there to work, and that's all there was to it. But I guess 2 or 3 months into his employment with us, I don't remember how the conversation started. I think it had something to do with him having to come and do his alcohol monitor or something. And I just asked him, I was just asking general questions, how that worked and what all he had to do and things like that. And it led into a conversation. Now, it was about a 2-hour conversation that we had. And I don't guess I've ever met someone that had the kind of maturity and insight into things at the age that he has. We've mentioned remorse 100 times. That goes without saying, Your Honor. He was remorseful, but more so than that, I think he knows that he's got something to give to society. He's got something in him. He's learned the hard way, and he's got a story to tell. He can help people in his situation. He's really, these unfortunate events have really put him in a situation to where he can do a lot of good in society. Good that I can't do, good that you probably can't even do, because we haven't been in that situation, and he has. Going back to what I was saying, people said that, I helped him and I taught him things. No, he taught me a lot. He taught me how to be a man. I mentioned he's about a year older than me. I just turned 21 a few weeks ago. I'm very young. And that conversation and conversations thereafter, because after that, it was pretty constant. I felt like he had something to give, and I wanted to talk to him. I wanted him to help me. I'm young, just like he was, just like he is, and he helped me a lot. He really did. I think he helped Matt. My partner, he doesn't talk much, and we hadn't talked much about it, but I know that both of us have been affected. I can speak on both of our behalves. We've been affected by him and his story and his maturity and the things that he's learned and the things that he has taught us. I think you know just as well as I do, whether anybody in here wants to admit it or not, because we all like to look at things, I guess through rose-colored glasses, that the prison system isn't what people want us to think that it is. It's said that prison is supposed to rehabilitate. I don't believe so. I don't believe that putting a man at 21 years of age in prison for upwards of 12 years is going to help him. He's not going to come out the same way that he went in. He's not going to come out with the same attitude that he has right now, the same attitude that he had months ago when we had that conversation. He's going to be jaded. He's going to be hurting, and he's probably going to be a little upset. Whether that's right or wrong, that's not for me to say. But I do believe that that's true, and I do believe that most people in this courtroom would probably agree with me on that. So it's up to you. You know that. There's nothing that I can say, I think, at this point, or that anybody can say.
You understand he's going to prison?
Yes, sir. I totally understand that. I do. Okay. I do understand that. I'm just saying, just as his lawyer said here, that 12 years plus. It's a mighty long time, Your Honor. And that's all I got. Thank you.
Thank you. You seem to be pretty mature for 21 yourself.
Thank you, sir.
Mr. Rusher.
Your Honor. I understand and accept the fact that I've been found guilty of causing the tragic accident that took the life of my friend Jordan. I would like to express how sorry I am to her family and loved ones. And that's something that I've wanted to do for quite some time, but have been unable to do so for a multitude of reasons. Jordan was one of the most beautiful people I've ever known, both inside and out. Although I only knew her a couple of years, she was a close friend who would do anything for anyone if given the chance. I hope to use this experience to benefit others, possibly prevent someone from going through a similar situation. I was abusing alcohol and drugs, and I drifted down a bad road as a result. One thing this experience has shown me is that I was not living up to my full potential. I intend to use this as a catalyst to turn my life around, to become an upstanding member of society, and to help as many people as I can who are struggling with alcohol, drugs, grief, or loss as I have. It is the least that I can do for Jordan, for my family, and everyone who still believes in me. That being said, I throw myself at the mercy of the court. Thank you.
That's all we have, Your Honor. Okay, I'll give you the last word, like I said, but
Okay.
I'll turn it over to the state at this point.
All right, Judge, first I'd like to invite the victim's father, Jordan Nedeau, to speak.
Your Honor.
Afternoon.
Name is John Nedeau. I'm Jordan's father. Dear Judge Lewis, a father never expects to write a letter such as this. Deep down inside, I still hope and think that Jordan's death is just a really bad dream. I still remember August 2nd, 2014 with details. Jordan was missing, and her little sister Jenna was at her friend's house. My wife and I agreed to give Jenna one more day of believing her sister was fine, as usual. Jenna's older brother Josh was with Audrey and I waiting at the sheriff's department to find Jordan. After hearing the tragic news, we knew we would never be the same again. I continually thought of how I would tell Jenna the unbelievable news about her sister, Sissy. That was a nickname. That morning our friends brought Jenna home, and then I had to look into my daughter's eyes to explain the horrible, life-changing news. I absolutely hated that moment of my life. There are days I wish I could forget. Now there are days I will never get to experience because Jordan is not here anymore. I'll never get to hold her children and spoil them. My wife has lost her firstborn princess. Our son Josh has lost his big sister and best friend. Jenna is almost 7 years younger than Josh, and she can't truly comprehend what this means to her. There's no way to quantify what we've lost. The holidays and vacations will forever be different now. It's painfully hard to put into words how Jordan's death has affected my family. This has been so unbelievably difficult on us all. We will never get to laugh and cry with Jordan. No share in growing old and live life together. Your Honor, I hope Mr. Rushing gets a 25-year prison sentence. If that isn't an option, then I respectfully ask that he serve a minimum of 20 years and 32 days in prison. This is the number of days Jordan Nedeau lived. I also request that his prison sentence be followed up with serving 5 years of probation, including installing an in-car breathalyzer during his 5-year probationary period. What has this tragedy done to my family? This has changed us forever. We will forever be trying to put our lives back together so we can be normal again. I will never get to hug my daughter, Jordan, again. I will never get to say I'm sorry or how proud I am of her. I'm only left with trying to figure out how to hug a memory or a picture of Jordan. If I could have just one more day. Sincerely, John Nedeau, Jordan's father. Thank you, Your Honor.
Thank you.
Judge, next we have Jordan's mother, Audrey.
Afternoon.
Yes. That's great, yeah.
Dear Judge Lewis, Jordan, my sweet princess, was taken from my life. In one of the most horrible ways a parent could imagine. Her death was completely avoidable, completely inexcusable. If you have never lost a child, you cannot understand the heart-wrenching pain that a parent experiences. The pain is so great that you feel the tightening, the physical tightening of your chest, as you cannot hold back the tears that stream from your eyes. It is uncontrollable. Seeing other mothers with their daughters, doing everyday things like school shopping, hearing of their friends' college graduations, the engagements that are now occurring. Each happy moment for her friends is a sad moment for me. I know that Jordan would be experiencing those moments today. She worked so hard to excel in school. She graduated with honors from her high school, and she was a current TCC student. She worked so hard to take care of her body in order to avoid diseases like cancer. She only ate organic foods. She tried so hard to be healthy. She wanted to live a long, healthy life and be someone who took care of others. Even from the time she was a toddler, she had a nurturing spirit, especially having an affinity for the elderly. Her friends continue to tell me stories that show her heart expressed in everyday life. She was the most non-judgmental person I've ever known. She did not see socioeconomic status. She did not see rough exteriors. She saw through all of that and tried to see the hearts of people. She had so much good to give in this life, and she will never be able to now. Just imagine someone looking into your child's eyes and then leaving them to sink beneath the waters that would soon take their life. This person is cold-hearted. How could someone do that to someone? This action has caused my beautiful daughter to be reduced to a horrible box of ashes that I have hidden in a closet because if I accidentally see it, I can't handle it and I break down and I can't stop. I just want to hold her and kiss her forehead like I did so often when she needed comfort. This child was me, in a smaller, younger body. She looked like me, she spoke like me, she acted like me. Looking into her eyes in pictures are like looking into my own. There's a hole in my heart that will never be completely healed. It will always be there until I die. I begin each and every day by praying that my family and my family's hearts will have healing as much as God will give us that day. Jordan has so many friends that were devastated by her loss. I continue to hear from them and how they miss her. Their voices should be heard as well. She touched people everywhere she went. And even at the memorial service, we had teachers and classmates all the way from kindergarten up through college. She was simply unforgettable, as they say. As a mother, not only do I have my personal grieving to deal with, but also seeing the pain that her dad, her little brother, and her little sister have. I hurt not only for me, but for the weight of the family I have on my shoulders. My tears are so big and so full of pain that it is still unbearable. Seeing my family cry and knowing there is nothing I can do to take their pain away feels like my heart is bleeding inside. I have prayed for you, Judge Lewis, that you will have God's guidance in your decisions. I pray for my ability to fulfill the commandment to pray for my enemies. And Jeffrey Rushing is the closest thing I've ever had to one. So I will pray for him during his incarceration. I know this is what God wants me to do, and I also know that that's what Jordan would want me to do as well. Sincerely, Audrey Nedeau, Jordan's mother.
Thank you.
Great, Judge. Next, I'd like to have Ms. Potluck from my office read some statements that were prepared by other family members.
All right.
The first statement is from Jordan's brother. Jordan Ray Nedeau was my best friend. She was everything I could have wished for. She was always there for me in any situation. She was the perfect sister. She loved the world and everyone who dwells in it more than herself. An uncountable amount of time she put me before herself, going out of her way to help me with whatever I needed. If someone died in my life, she would be the one I would go to cry on her shoulder and to look for guidance. Ever since birth, she was always there by my side, experiencing everything we did together. She was so beautiful and just perfect. I always had thoughts and dreams about how she would end up with her future husband and family. I always imagined having my kids go and visit Aunt Jordan and have the best times because I know she would have treated them like her own children. Ever since she left this world, my life has not been the same. My heart feels as if a huge empty space, a black hole. It can never be filled up. She was a huge part of my life. I thought about her every single day of my life. I loved her. She left this world in the worst way. She got left behind by a selfish, so-called friend. He was a bad influence to her and ended up leaving her behind to die. If I was in his place that night, I would have died, because I would have done everything in my ability to save her. I would have drowned myself trying to save her, rather than worrying about my own self. She lived a beautiful life, and truly she deserves to live a life more than me or anyone else I can think of. Every night when I close my eyes, I see her. I could go on and on about my feelings, but nothing I can do can bring her back. No sentence that you can give Jeffrey Rushing will change anything. He deserves punishment, but I will still live my same life wishing I would have been there to save her. God holds the real punishment. Sincerely, Joshua. The next statement is from Jordan's little sister, Jenna. My name is Jenna, and I'm Jordan's little sister. Jordan's death has impacted my life in such a way words cannot explain. A piece of me has left, a part of my life I needed to have in order for me to stay happy. I went to her for everything, and she came to me for things. She gave me advice and told me the truth. She was an honest person and was an innocent human being. She did not deserve this. I hope the person who is responsible for her death is put to justice for a long, long time, or at least until he is truthfully sorry for all the misery and pain that he has caused for so many friends and family. But maybe one day he will understand and what his actions have caused. I felt dead inside ever since her death. I have felt like I have lost the one person that I could love so greatly in this world. I feel and have felt abused inside and could not bear it any longer. She still holds a special place in my heart and always will. I want the person who is in charge of Jordan's tragedy to be put in jail for so long that he forgets what year it is, if that's possible. This has impacted my life too much to even explain anymore. All I can say for right now is that I'm hurt, so deeply hurt. Put him in jail for at least 20 long years of thinking about what he could have done differently to save my sister's very life. Have justice be done to him. From Jenna. The last statement I have are from Jordan's grandparents. Your Honor, we write this letter with a very sad and heavy heart. We lost our sweet granddaughter, Jordan, 1.5 years ago. It's not normal to outlive your grandchildren. We miss Jordan so very much, her smile and her hugs. Words can't express how great our loss is. There's just no words. We will forever shed tears for Jordan. At least we have wonderful memories to help us smile sometimes. We hope the maximum sentence prevails in this case. Our lives forever have changed in so many ways. Thank you for your time. Diane and Denver Ingram, Graham and Granddad, to Jordan.
All right, Judge, next the state would like to invite a close family friend of the family, Shannon Rozier. Ms. Rozier is going to read some statements from some of Jordan's friends, and then she'd like to make a couple comments as well.
All right, Ms. Jordan.
This is from Haley Hinton. Dear Judge Lewis, I met Jordan the day I was born. I can't tell you what my first impression of her was because I was too new to even keep my eyes open. Her mom brought her to the hospital where my mom was recovering and laid her next to me for a picture that I still have today. We grew up side by side, often in matching outfits like sisters. She was someone I could count on when I needed a positive attitude or an honest opinion. One of the last times I asked her for advice, she reminded me that no matter what, things never fail to get better. Losing her has challenged that for me, because after all the time that had passed, I can honestly say that this is one thing that hasn't gotten any better. I was sitting at Jordan's friend's house when I got an anxious text from Jordan's little brother. He wanted to know if I had heard from her. He felt that something was wrong and that he wasn't getting the whole story from her friends. I remember telling my friend that I needed to go meet him at Jordan's house to calm his nerves and that I would be back shortly.
I had no idea that I was about to spend the entire day down Tower Road, drenched in sweat, repeating to everyone like a broken record that everything would be okay. The half-truths told by the people who were supposed to be Jordan's friend sent us on a wild goose chase for closure. It wasn't until around 3 or 4 a.m. the following morning that our search ended. Those hours felt like an eternity of anxiety, frustration, and forced optimism. The following night, I cried myself to sleep next to my mother in a hotel bedroom, and my eyes were wet with tears before I even opened them the next morning. One thought haunted my every move. If I had been there, I would have done something. I have struggled with that ever since her passing, longing to be the other person in the vehicle or longing for that person to have been anyone other than Jeffrey Rushing. I firmly believe that had it been any other person, the outcome would have been much different. Jordan may not have survived, but she would not have been deserted. Since her passing, I have felt grief with an intensity that I have never known. I struggle to find the drive to get out of bed in the morning or perform simple tasks like brushing my teeth or cooking breakfast. I have spent late nights speaking out loud to an empty room as if she were there and could somehow hear me. I have woken up from dreams of her only to feel the harsh reality of losing her all over again. Jordan was a sister to me, and her future was bright. She was surrounded by people who dimmed her light because she and I searched tirelessly for a suitable place for her to move to only weeks before her passing. Believe me when I say she was on her way out. I will always ache for her presence and shudder at the thought of her in that cold river all alone while her only chance for help ran to hide from what he had done. Most of all, I will miss who she was and who she was going to be. I will long for the future that was taken from her when she was taken from us. That was Haley Hinton. This is from Jessica Singleton. Dear Judge Lewis, wow, what an amazing soul Jordan was. She has introduced me to so many people. She was only able to do so because Jordan saw everyone the same. She saw no social status. Nobody was below her. She recognized goodness in people I never noticed that I could overlook. She made friends with a girl who was on the bench alone once with no significant reason. She brought freshmen to our lunch table during our senior year. She just wanted a smile. She changed my life from braces to college, and one couldn't count how many people who consider her a best friend. Talking to Jordan just a day or two before she passed, we planned for her to come see my son in the hospital as he was being born. I was 8 months pregnant at the time she passed. No one else came that day. She was the only one I would have ever wanted to be there. Today, I see a therapist once a week to learn how to cope with my fear of losing my child. I cannot go to the grocery store alone, and I avoid parks. I rarely take left turns on highways because I can't risk being in a car accident. I cannot feel the pain I see her parents suffering. If God could take Jordan away, I feel he could take my innocent son away as well. As extreme as it may seem, Jordan's persona, her elegance, her innocence, and her inability to let a person down is a comparison to that of a sweet, innocent little child, the kind of child that makes you laugh at their clumsiness and melt at their pure heart. I fear I will never stop accidentally dialing her number or trying to send her pictures, and I have not found anyone to take her place to listen to me when I needed a friend, or anyone who would know exactly what song to put on the car at any given time to cheer me up. Jordan is an irreplaceable person in my life, and I will forever be impacted. And the last letter is from Paige Harrell. Dear Judge Lewis, there's not a moment, a day, or even an hour that I don't miss my best friend and classmate, Jordan Nedeau. There's a few moments in life where you meet someone who changes your life. Jordan was that for me. She was my BFF and my confidant. Jordan knew how to really listen to someone and care about every word that comes out. She lit up every room as she walked in, but more importantly, she lit up my life. She gave me confidence in myself and made me feel loved and cared about. Jordan was an amazing friend, daughter, and granddaughter. Her life was taken too soon. We mourn every day over this loss, and sometimes we realize we'll never stop mourning. Thank you very much for your time. I would like to speak on behalf of myself. I have been a long family friend for well over 8 years. Started out to be their CPA, tax preparer. That's moved into a friendship. I have 4 children total. 3 of them are in college. So our children were very close in age. However, they did not hang out. One of the biggest misconceptions that I feel that has been brought to you is the word remorse. So I just wanted to make sure that I corrected the fact that the defendant might have remorse, but we, the family, the friends, have not seen any of it. He's never even looked at my best friend and said he was sorry. He's never said anything. His attorneys have never reached out to extend any type of remorse for anything. And I don't know if by doing that prior to the trial would have been an admission, but there hasn't been any remorse whatsoever to the Nedeau family. We never even came to our own conclusions. We let Georgia, with the state, do the best job she could do, and that helped explain to the family what actually happened that night. We were here in the trial learning about everything. So at any point of time, he could have turned to them and told them just how sorry or remorseful he was, or while he was standing up here talking to you, it doesn't hurt to turn around to the family. So I just wanted to make sure that I identified to you that he might be remorseful on that side of things, but on the Nedeau side of things, where I think the remorse should be, there's been none. Not from, not to the mother, the family, nothing. We've gotten nothing. So I just wanted to make sure that I made that clear. The impact is substantial. The way that I have to, call to my friend and make sure that I counsel her and make sure we have red flags in place, because, mothers can go into a deep depression, after losing any child. So it has definitely been an event that doesn't have a how-to manual that comes with it. Every family is dealing with this differently, and I'm sure whatever decision you make will be justified, but I just wanted to make sure I corrected the fact that the Nedeau family hasn't seen or heard or, had any bit of ounce of remorse whatsoever. Thank you.
Judge, the state is objecting to any departure from the guideline sentence. The guidelines call for 145.5 months, and we would ask Your Honor to consider that the floor, even to the extent that you feel that one of these grounds has been proven. We'd ask that you use your discretion not to deviate below the minimum mandatory sentence pursuant to the score sheet. Yeah, there's a 4-year minimum mandatory, but there is a 145.5 month minimum sentence pursuant to that score sheet. May I approach?
Yes, ma'am. Let me ask you something else in terms of legal sentence. Do I remember that the manslaughter and vehicular homicide, we can't have a conviction for both?
You're correct, sir, and I've only put the count 1 and count 3 on the score sheet. I'm assuming that Your Honor will find that count 2 is subsumed into count 1.
Okay.
So, Judge, a couple things about the defense's argument for downward departure on the basis that the offense is isolated and unsophisticated and for which he's shown remorse. I think they failed to prove that it's isolated and unsophisticated. In his law enforcement interview, the defendant made several comments. Now, some of these were redacted for the purpose of the jury, but several comments that he had partaken in these substances before. Now, I don't know if he made a habit of driving under the influence of those substances, and I don't know. I mean, obviously, he's never killed anyone else, so in that sense, it's isolated. But I don't think they've proven that these types of behaviors were isolated. I don't think he's shown any remorse that can rise to that legal hurdle. He indicated that in his interview that he should have told Deputy Bragg. I'm sure you recall that he went for a ride with the deputy after the crash and didn't mention anything about this. And he said in his own words, "I have no good reason as to why not." And I would submit that the reason why not is because he was trying to save his own skin. He had no remorse for what he had done, or to the extent that he did, it was overcome by feelings of self-preservation. I want to mention that this isn't a situation like we do sometimes have where somebody had one too many drinks at the bar. This defendant was under the influence of multiple illegal substances in addition to alcohol, and that's by his own admission. I do think it's important the way the victim died in this case. It's different from dying instantly from a head injury in an automobile accident. She did suffer. She did die in a horrible way. As her mother's told you, she relives all the time thinking about the way her child died. And I also think it's very important the fact that he left her there alive. I know Your Honor recently sentenced a similarly situated defendant to 15 years. And I think it's important to note that in this case, in that case, the victim was obviously deceased when he fled and left and didn't get help. But here we don't have that. He could have helped her. There was a chance and he didn't do that. And I think that's really important for sentencing purposes. I don't think they've shown remorse. In fact, I recall him kind of laughing and having a strange demeanor in the interview. And one of the jurors asked a question about that. Can we consider that? Or something about his demeanor in the interview being laughing. So I think that's important that the jury noted that he wasn't showing remorse, at least at that point. Now that he's here trying to get 4 years instead of 20, he's got a lot of remorse, but we just haven't seen it up until now. And he did try to blame the victim at the trial. The whole defense was that she was the driver. I don't know if that's changed today or if he's still maintaining that. He gave a statement today, to Your Honor, and I apologize, I couldn't hear all of it, but I didn't hear some of the things I would expect to hear for somebody that was deeply remorseful for the tragedy that they had caused by their own actions and their own choices. I didn't hear him say, "I'm sorry for what I did. I'm sorry I made the choice to drive. I'm sorry that I didn't help her when I could have. I'm sorry for all the suffering that I caused this family and my own family." I didn't hear any of those things, and maybe he said some of them, I don't know. But I just don't think they've proven remorse, and I don't think they've proven that this defendant did anything to cooperate with the state to resolve the offense. I mean, yes, he went to law enforcement, but the testimony was that that was done as a last resort. In fact, I think Skylar Smalley testified that they had exhausted all other options. She was missing, so there was going to be an investigation at some point, and they made the decision ultimately after 16 or 17 hours to go to law enforcement, not in his first contact with law enforcement and not during all those other opportunities between his ride with Deputy Bragg and the ultimate decision to go into law enforcement. And I have a quote here from Skylar's testimony that he was reluctant to come forward because he didn't want to get in trouble. So there again, we've got a lack of remorse or remorse overcome by, the need to save his own skin, which is, I think, what we're here about today again. It's all about him. He's going to use this opportunity to do something good. He's going to have a life after this. He's a good kid. He's this, he's that. Well, there is a multitude of suffering on that side of the room, but it just can't touch the other side. His mother can go see him at the prison, and Jordan's mother never can. And yes, there's no way to bring her back, but justice is important. It's important to the family, and I wanted to point out that during the course of the trial, I handed the photographs to the jurors, tried to protect the family from seeing some of the images that were introduced into evidence. But I think it's important as the sentencer that you see some of these photographs. I've selected a few, and I'm not sure if you had the opportunity during the trial to see them, so I would like to hand them to you.
Okay.
If that's acceptable.
Sure.
They just are impactful. So I'm not going to say a number, Judge. I mean, I've mentioned the number, the bottom of the guidelines. I've mentioned the number 15 as what I think a ballpark place to start with something you've done similarly recently. And I've mentioned some factors that I think maybe make this case a little bit more egregious. You heard the number 20 to 25 from the victim's father, and I think that would probably be appropriate. So I am going to leave it up to your discretion, but I will ask you not to deviate below the guidelines and to impose the minimum mandatory. In addition, we have some funeral expenses that we're seeking in restitution. And I understand we have a stipulation in reference to those. And I'd like to submit the funeral bill, which is $7,450.80. And I also would like to submit copies of the written statements that were read into the record today to the court file.
All right. And is that payable to the parents?
Yes, sir.
And regardless of what sentence I give, are you suggesting probation would be appropriate as well, following that?
I'll leave that up to your decision, Judge.
Okay.
It does seem like after a lengthy prison sentence, it might be a nice transition to have some term of probation, but I'll leave that up to you.
Okay. I'll give you last word on this item.
Yes, Your Honor. You know, it's not easy, Your Honor, defending someone when someone loses a life. And if I made an error and instructed my client not to look at the family when he spoke to the court out of respect for the family and their loss, I would ask you to hold that against me and not my client. I directed him not to talk to the family, not even to look at the family when he apologized to them. I believe it's inappropriate. I would never do it considering the situation, circumstances, and I advise my client not to do it. I also have a little issue with Mr. Rosser. We reached out to them. I reached out to her during the trial. And only after the trial and the conviction did she accept and talk to me in the parking lot after the conviction in this case. There's another family friend, a lobbyist named Samuel Ard, who's a close family friend of the family. I did not feel comfortable reaching out. I instructed my client's family not to reach out. I reached out to Sam Ard, known him for many, many years. I reached out to him yesterday out of respect to him and to the family to let them know what we were doing today, to let them know that we were filing a motion to depart, that we would be asking for the minimum mandatory. And I said, I just want to let the family know so there's no surprises out of respect for them. He reached back and said the family appreciates me doing that. So whatever we did, I assume responsibility. I know that that family is reaching out. I know family and friends are. But if I made misjudgments that my client or my client's family should have reached out to them, I take responsibility. Blame me. Because I don't usually allow my clients or their family to talk to the victims in the case. I just don't believe it's appropriate. I believe that when the victim's family is ready, they will reach out, or the victim family will reach out, or somebody or the state attorney will reach out. So that is why that was done that way. Judge, this would be easy if it was a crime that had a specific intent or a general intent crime, and you had an evildoer who had evil wishes and he did evil things. But that's not what this crime is. It's a strict liability crime. You drive, if you're impaired and injuries occur, you're strictly liable. You may not have intended it to happen, but you should have known better. That's what we have here. No one says my client's an evil person. No one can prove he's an evil person. And no one can prove that he wanted anything like this to happen. But that evening, if we want to talk about the testimony, Jordan Nedeau wanted to go. She wanted to drive this guy home. She wanted to drive. And for some reason, my client ended up driving. Okay? No doubt about it. They were both in that car. 3 of them were in that car. And he may not have wished it to happen. He certainly didn't have the intent for it to happen. But under the law that we have, you're strictly liable. Now, tailoring the sentence, and it's easy to be emotional, and I'm sure that's why the judge issues a sentence. That's why they actually make guidelines. That's why they do a pre-sentence report. Because every person is an individual, is a human, comes in here with a background, comes in here with either a criminal history or no criminal history, and then you apply the facts and you have the discretion. And the courts and the legislature says, if these guidelines apply, you may mitigate. Judge, there is no doubt, I believe this crime would have not been solved. There would not have been a DUI conviction had not my client went in there and given that interview, admitted to drinking 14 beers, and admitted to all that thing. This crime there would have been no conviction. So we do believe under that provision, he did cooperate, he did assist them, and he did help them solve a crime, and he didn't invoke the rights. He gave an interview. I don't believe I ever saw him laughing. He was confused. We put Pritchard on the stand for a legitimate reason, and the state uses Pritchard a lot. And Pritchard found his conduct. He could have had a blackout, which could explain why, when the officer Bragg showed up, he didn't know where he was. He wanted to know where his car was. And that's besides remorsefulness. Remorsefulness for this departure is determined at the time of sentencing. And at time of sentencing, now, should I have him stand up and approach the family? I'm not going to do that. I told him not to. I told him to address the court. And when he spoke to the probation officer, he spoke with a heavy heart. He had to stop the interview 3 times. That's what she said. That's what the probation officer said. That's remorsefulness. The courts have said finding remorsefulness, even at the time of sentencing, is sufficient for the court to make a finding that that element has been satisfied. We believe, Judge, he has been remorseful. He will be remorseful for the rest of his life. And I don't believe it will be ever satisfactory to the friends and family of the victim. I agree with that. He can never be remorseful enough. He also can never change what happened that night. So we're asking you, Judge, we believe that the first departure also applies. He did cooperate. He confessed. Does apply. And we ask you to tailor a sentence not based on emotions, but based on the whole package. That's why we have pre-sentence reports. That's why it's important when someone who's never been convicted, never been sentenced to prison, when they get convicted of a crime, they're entitled to a pre-sentence report. In that report, probation officer recommended a period of incarceration followed by a period of 5 years probation. And if the court wants to make sure that this individual gets out, it's going to get out eventually because of his record and because of the guidelines, to keep him and give him an opportunity to try to be more remorseful, try to be productive to other people, we ask you to consider the departure. And even if the court considers the departure and doesn't give him the 4 years, we would ask you to consider the departure from the 144, tailor a sentence of incarceration, tailor a sentence of probation. Since the day of this, he has a sobriety date since the day of this accident. He's worked, he's gotten a job. It sounds like the job wasn't that great a job. Landscaping's not easy. Getting up at 5:30 and doing it is not easy. But it shows that he has the ability to be productive. And no matter what I say, no matter what you sentence him, we can't bring Mr. Nedeau back. But we can at least try to tailor a sentence that's just.
What's the maximum sentence?
Well, I think it's... How much?
45.
So it looks like...
I think that's right, because you can't double sentence.
It looks like the manslaughter is an F2,
Yes, sir.
That's correct.
but the leaving the scene is an F1.
Yes, sir.
That's right.
Okay. So maximum is 45 or 40?
45.
45. Okay.
That's all we have here.
All right.
I'll have him come forward.
Was there anything else you want to say?
Do you want to? If
It's all right.
I don't want it to be held against him because I told him to do something, Judge.
Okay. I just want to make sure that everybody has their opportunity to speak.
Did you want to
Do
follow?
not address George's man.
If you want to.
I just wanted some clients to go and approach and tell the parents sorry for me you lost. I understand there's nothing that I can say to bring Jordan back. There's nothing that I can say to make him feel better. And I understand the way that y'all must feel towards me. And I hope that one day, by the grace of God, we can mend that relationship and come to a point where we can both say that we love Jordan and that we miss her and that it was a terrible accident. So, provide. Thank you.
Well, I appreciate the comments of everybody, the letters I got and the comments today. And I wish I was half as articulate as the people I've heard today express their opinions about this. And the law does impose upon me a pretty heavy responsibility in cases like this. One of the worst that I think that I have to deal with, because almost always I have what I have today. I have somebody who has absolutely no prior record, stellar academic performance. The support of family and friends is incredible, and in all respects, just a great guy who has made a terrible decision. And I have on this hand somebody who is, as the mother said, has got a hole in the heart, can't be replaced. Nothing I can do. And you know, let me go over the departure things. I think you make a pretty good case for it. I'm not sure cooperation with the police applies. You know, you say, well, I don't think this thing would ever been solved. We wouldn't have had a crime. We'd never been convicted. I don't know. I don't know that I'd go that. Certainly it helped. And I got people that make statements to the police all the time that end up being used against them. So I don't think that really qualifies. And you're right. This is different from a crime that requires a specific intent, or I've got some pattern of conduct. I think just about any manslaughter DUI that I have is going to be unsophisticated by its very nature. It's a negligent thing. It's not an intentional crime. There's no doubt in my mind that Mr. Rushing didn't intend what happened. Isolated incident. State suggests that maybe, you know, he had a pattern of using drugs, probably had a pattern of driving while he did too. I don't know if that constitutes then an isolated incident, but assuming it did, we come down to the remorse, and I think the state makes some good points too. You know, a lot of what happened, you never know until you get to the situation there what you're going to do. But Mr. Rushing didn't do anything about it. Did seem to be more concerned with getting in trouble than to see to his friend, who he didn't obviously know what the situation was. We'll never know what really happened that night. Don't know whether you could have gotten in there and gotten her out like somebody presumes you could or not. Maybe you know, the trauma that messed up your memory. Don't know. We sometimes want to remember things in a way that's more favorable to ourselves. So I know that. You'd like to think that you did everything you could. Remember, don't know if you did or didn't, but, you know, the bottom line is, assuming it did apply, I'm not going to depart, and I'll tell you why. Not that I think that you're a bad person, not that I don't think that you got a lot to offer, not that I don't think that you are in fact remorseful at this point. You thought about it, and you are sorry about what happened. But on the other hand, you know, the law looks at this like when you engage in activity, which, you know, quite frankly, this is my pulpit, I guess, we take not seriously enough. We kind of wink a little bit. We're getting a little better, but we kind of wink at people that drink. That's fun. We drink, we do drugs. That's good. We're just having a good time. And we drive. We got to drive. We got to get places. Well, I'm not quite as messed up as you are. I'll drive. Not a good decision. And we get people, the same activity would be a misdemeanor if nobody got hurt. That's the way we treat it. But it's the same activity. But if you do it, you just, as your attorney says, you got to know. You ingest the amount of chemicals that you did. You get into a car and drive and somebody gets hurt. The law says we take that very seriously. As the family says, I can't ever replace that wrenching pain that you have. So it to me is just not respectful to a life that's been lost. I can't replace it, but to me it's due respect for a life that's been taken by the criminal act of another means I should treat it seriously. But I do take into account the person. I do take into account that you have no prior record, which is a very important thing. A lot of people with a bad record come in and tell me I shouldn't be punished for what I did in the past. And I say, well, you'd want me to reward you for what you did in the past, wouldn't you? And they say, well. So I do take that into account. But I also like to be consistent, as Ms. Cappleman has just pointed out. I had a case, unfortunately, very similar to this not long ago with a person with no bad record, all the things going for them. And the only thing I can hope is that when you do tell your story, you won't be embittered after your prison sentence like your friend suggests that you might do. But it makes a lot more impact if somebody says, what did you get? And you tell them. And maybe at some point, as a society, we'll realize we can't do this anymore. So I will impose a sentence of 15 years, Department of Corrections, credit for time served as of the day, which would be 80? What's the day? 323? 80 days. There is a minimum mandatory on that I'm going to run these concurrently, so there'll be a minimum mandatory of 4 years. Does that go on the manslaughter or
yes,
the?
Sir.
Okay. There is restitution to be paid, so I'm going to put you on probation 5 years as recommended by the person that did the pretrial interview. Restitution, it looks like you are determined to lick any kind of substance abuse problem you had. I'm going to make it no illegal drugs, no alcohol. I'm going to monitor that by random UA's alcohol checks, but I'm not going to require you to do any kind of treatment. I'm convinced that you'll take care of it yourself. But don't mess up, because you heard what the maximum sentence is if you mess up. So it'll be followed by 5 years of probation. With that condition, the restitution payable to the parents. You, as a matter of administrative, you will lose your license, permanent revocation based on the charge. But I'll say no driving as a part of your condition as well. You can, after your probation, if you work it out with them, get your license back once you get out. Was there any other condition of probation either side thought was appropriate?
He's not to consume any alcohol while on probation?
No, ma'am. Nor any illegal or non-prescribed drugs. Okay. Did you get the restitution amount, Kevin?
It was $7,450.80.
Yes, yes, ma'am. And then court costs and fines and fees are total.
The total is $2,875. $2,100 is the fine, 5% is $105. There's
Okay.
$135 big loss assessment, 15 is drug, alcohol, the first crimes. 420 court costs and $100 cost of prosecution.
Request a civil judgment, Your Honor.
Well, I'll let him work on a payment plan when he gets out. Let's say 90 days after you get out, a payment plan. If it works out, I'm going to be optimistic that you'll be able to do that. All right. Thank you. Good luck to you, Mr. Rush.
Count 3 is that how many years?
Count 3 will be the same. These run concurrent. And count 2, I guess we show as, I don't know what you say about it. You're right. It's assumed in there.
Judge, I think there's an amendment on both of those.
On leaving the scene and manslaughter?
Yes, sir.
Okay. So what would be the proper wording on the vehicular homicide that's no longer here?
That it was subsumed into count one.
Subsumed into count one. Okay.